attention students, and greetings from the National Law School. I am Professor Sarasu Esther Thomas, and I'll be taking you through a very interesting topic, that is women's rights as human rights. Let me quickly take you through the contents of this module, women's rights as human rights. We start off with an introduction and the history of women's rights, and then we go on to the International Standard on Women's Rights, that is a convention on elimination of all forms of discrimination against women. We move on then to a very domestic context. We look at the Constitution of India, we look at equality provisions in the Constitution, and then we move on to a controversial area, which is the public-private divide. And this area we will examine from the lens of domestic violence. Since India is a country with different cultural realities, we have incorporated a module on cultural relativism, and we will be examining this concept from the perspective of family laws, also called personal laws. We look at another important area for women's rights, that is anti-trafficking law, and we look at it juxtaposed with the women's right to sex work. In the last module, we looked at reproductive rights as sexual rights, something very important in a country like India, where we are working towards making difference costless. Finally, we conclude with analyzing the way forward and see how legal and social transformation can lead to a better world for women and better human rights for women. Let's now quickly go on to the first chapter. That's an introduction and history of women's rights. Frankly speaking, a module on women's rights is a necessary part of any serious human rights course. And this course looks at international and national standards through a critical lens. We understand that in a course of this nature, it is very difficult to cover every aspect of women's rights, but it is possible to look at important issues and debates through the context of these standards. And this is exactly what I have tried to do in this module. So the focus is on learning through critical analysis, not simply learning provisions by rote. Now briefly, although there are claims of the recognition of women's rights in early societies, very few of them are actually borne out by historical fact, if any. In the Western world, where the idea of human rights took root, the notion that women were also equal and that they are also rights-bearing individuals as men are, took a long time to be accepted and was not easily accepted. For those of us in Indian society, we know that's true of our societies as well. And we still have many areas where women are still not equal. Although there were formal declarations of human rights, when we see the French Declaration, you see the American Declaration, both of them are completely conspicuous in their silence on dealing with women as equal partners. Although later we do see that the French Declaration on the Rights of Women was drafted. Let's quickly move on to looking at the convention. If you remember, the CEDAW, which we discussed a few moments ago in detail. Now the CEDAW as an international instrument tries to address human rights by asking what we call in feminism the woman question. And there are four major planks on which the CEDAW is placed. The first is equality, the second non-discrimination, the third non-stereotyping, and then finally state obligation. Now when we look at equality, there are many models of equality. The traditional model is what we call formal equality. Formal equality means treat A and B in the same way. Treat men and women in the same manner. Now this model of equality does not work. And because this model of equality did exist in human rights law, it was felt that this was not something that was serving women's interests. So the model of equality which the CEDAW takes into account is what we call substantive equality. Substantive equality acknowledges the differences that women have, or the challenges that women face, the barriers that are there in women's lives. And it tries to make these differences costless, meaning it tries to make sure that women don't pay the cost of being women. It tries to avoid gender blindness and moves on to gender sensitivity. It tries to ensure that imbalances both in the law and in society are addressed in order to lead to better provisions for all women. Now, to understand models of equality, let us quickly look at different perspectives on women and equality under different schools of feminist thought. Certainly, I would recommend that you have to read your materials in order to get a better understanding and read up where you can. So feminism is not all the same everywhere. There are very many different schools of feminism, as we say, ranging from liberal feminism, which talks about equality of opportunity of men and women, and that they should be treated equally, to radical feminism, which talks about the subordination of women because of male dominance, and other schools of feminism like cultural feminism, postmodern feminism. I could go on and on, but let's get back to topic. The other area that we need to look at is non-discrimination, the second plank of CEDAW. Equal treatment, unfortunately, does not necessarily lead to equality. So CEDAW specifically mentions non-discrimination and allows for corrective measures which will not be treated as discrimination against men. To give you an example, there were very many early cases where women were discriminated against based on biological factors like pregnancy or menstruation. So not giving maternity leave, for instance, is discrimination against women. But earlier maternity leave was never given because men cannot use maternity leave. They don't become pregnant and have babies. So CEDAW, for instance, says you must take note of this difference. You must provide for maternity and all issues surrounding maternity. So it allows for what we call corrective measures to be taken to avoid discrimination. It also discusses not just problems relating to sex, like pregnancy, but also issues relating to gender, the way that women are treated because of social constructs of men and women. Gendered assumptions impact the way that women can access their rights. This can happen in many ways. Firstly, there can be a restriction in the rights and freedoms of women. For instance, the feeling that a woman's place is in the home and preventing her from going to work. Or, in the converse, believing a man's place is at work and expecting men to not do any work at home. The second is exclusion of rights. For instance, the belief that when a daughter gets married, she goes away from her home and therefore she should not have any rights to the property. This is a mistaken gendered assumption. The last is a lack of agency, that there's a belief that women should not be allowed to decide things on their own. We have in our own cultural traditions in India, Manusmriti, for instance, which says that when she's young, the woman must be in the care of the father, when she gets married with the husband, and when she's older, under the care of her son. So treating the woman as a free agent who can decide what she wants to do, where she wants to work, whom she wants to marry, is an important area that is lacking, the lack of agency. We also see that the last plank, which is non-stereotyping, is one of the most important planks and a unique feature of the CEDAW. So what does non-stereotyping mean? Stereotyping means fixing someone into their gender roles. And the idea of non-stereotyping is incorporated in Article 5 of CEDAW, which places duties on states to change the social and cultural conduct of men and women in order to work towards elimination of both sex-based and gender-based prejudices. And secondly, to abolish myths and prejudices relating to maternity and burden of women in raising children. So non-stereotyping basically means saying that women should do this, or should not do so and so and so, or that because of the superior position of men, this must be allowed, or treating menstruation as unclean, or placing disabilities on women because of her sex are completely to be prohibited. Such a revolutionary provision. States have important obligations under the CEDAW. They include protecting people against state actions. It includes making sure that if there is a human rights violation, the state will act by making sure that male power is not privileged and patriarchy is not pushed up because of state action. And so many more, which CEDAW is very specific on. There are a number of provisions in CEDAW, and Articles 1 to 4 specifically list out a number of state obligations. Article 1 defines discrimination against women. Article 2 imposes a duty on states to condemn discrimination in all forms. Article 3 recognizes the barriers that have prevented the development and advancement of women's rights, and it places an obligation on states to remove these barriers. Article 4 is what we call affirmative action. It allows temporary special measures to be taken in order to make sure that women's rights are on par with other rights. Now, what are the main principles of CEDAW? To incorporate the principle of equality of men and women in legal systems, abolish all discriminatory laws, and adopt appropriate ones prohibiting discrimination against women. Then to establish tribunals and other institutions to ensure effective protection of women against discrimination, and to ensure elimination of all acts of discrimination against women by persons, organizations, and enterprises. There are a number of functions that CEDAW performs. If you take a quick look at this chart, you will see a brief description of these, which range right from eliminating direct and indirect discrimination to the last one, to taking appropriate measures to ensure full development and advancement of women in all fields, and with everything else in between. Now, how has India responded to CEDAW? While India is a signatory, we have some declarations and reservations on this, meaning that we don't or we cannot accept CEDAW in full. There are 4 important declarations and reservations. The first is that we do have declarations on Article 5A and 16.1. 5, as we see, refers to non-stereotyping, and 16, as we will see later, refers to family law. Now, we have said that we will abide by it and we will ensure these provisions in conformity with our policy of non-interference in personal affairs of any community. This means that family laws in India can continue to be discriminatory against women. And in fact, almost every single family law discriminates against women in one way or the other. With Article 16.2, which talks about compulsory registration of marriage, we have a declaration that though we do agree with the idea, keeping in mind the vast illiteracy in our country, it's not practical to implement it immediately. We also see that there is a reservation that we have, which you can read, and it's not immediately relevant to what we are discussing right now. Now, in India, the body which exists at a national level, an institutional mechanism, is called the National Commission for Women. We also have in many states state commissions for women, which look at implementation of human rights in the states. Now, this was established under a statute because it felt that there was a real need for a national level body which would look at human rights in some detail, to suggest recommendations for laws, review laws, and to take actions in some cases where there were complaints. Now, the powers of the National Commission are again very broad, right from summoning a person to receiving evidence, to requesting for documents, to asking for public records, and so on, in order to try and arrive at the truth of the matter. We also see that the National Commission has been involved in taking up some key issues and bringing them to the attention of the media and of the legislature. Now, the next chapter we are discussing is called Constitutional Provisions and Equality Jurisprudence. Now, as we've seen in an earlier section, the CEDAW's model of equality is called real or substantive equality rather than mere formal equality. This is also true of the Constitution of India. I always say that to me the Constitution of India is a feminist document, very clearly so. Because the Constitution recognizes equality for men and women, but at the same time it also recognizes that unless we take affirmative action, it is not possible for women to attain the same level of equality as men. One of the reasons for this is that Indian society is patriarchal. It privileges males and has continued to do so. Because of this, we see that the bulk of property is held by males. Many women do not work or they earn less than males do. In families, there is a son preference which leads to a lower sex ratio where you find fewer girls being born in our country today. And women are generally considered socially inferior to men. And so challenging gendered norms is a real problem because women are not really considered equal. The Constitution is aware of this. And we see that both in spirit and its letter, real or substantive equality has prevailed. Now, there are three sets of rights under the Indian Constitution, or at least for our purposes here. The first is fundamental rights, which we find in Part 3. They're considered to be inalienable. You can't take them away. It's available to all. Then you have the directive principles of state policy in Part 4, which are principles a state should be guided by in its actions. And then you have other constitutional rights scattered in different places, parts of the Constitution. Now, these are some fundamental rights relevant to women. Equality, of course, prohibition of discrimination on the grounds of, among other things, sex, equality of opportunity in employment, prohibition of trafficking or human beings and forced labor. Some directive principles of state policy are also useful to look at very quickly in the context of women's rights. For instance, securing a just, equitable order, equal justice and free legal aid, village panchayats where women now have representation, right to work, to education, to just and equitable and humane conditions of work, maternity relief, living wage for all workers including women, uniform civil code in family law, compulsory and free education for children, and so on and so forth. So we see that there are so many different directive principles useful for women. Now, while studying the right to equality, which is the most important right in my opinion, when we compare it with international standards, we see that equality means two things. One is equality in both the text of the law as well as in the procedures. Secondly, non-discrimination on the grounds of sex. And lastly, affirmative action for ensuring real or substantive equality. Equality in the text of the law means that you can't have laws on paper which give women less rights than men. The Constitution is very clear about that. You can't have a law which says, for instance, that men will be paid more than women for the same job. You cannot also have a law that discriminates on the ground of sex. For instance, a law that says that only people who are 6 feet tall will be employed straight away discriminates against women. So unless there is a need for someone to be 6 feet tall. That will not be considered to be a proper law. Or laws that keep women out of certain jobs, like the armed forces, for instance, believing that women are weaker, are now effectively being challenged all across the country today. There have been some important cases which have really strengthened the position of women in India. The first is a case of Anuj Garg versus Hotel Association of India in 2007. In this case, there was a rule made by a state government that no woman or a man below the age of 25 could be working in an establishment where liquor was being served. This was challenged on the basis that it discriminated against women because it prevented them from being employed in a place where liquor was served, and placed an undue burden on women by excluding them from participation in such employment. This also meant that there was a difference created on the basis of sex, with different roles for men and different roles for women, with what was suitable for men and what was suitable for women. This was successfully challenged, and the court said that such a rule would not stand. It would be discriminatory against women. There are two cases that I'd like to pull out from this year which have had a bearing on women's rights. The first is a case of Joseph Shine versus Union of India, which dealt with adultery law. Now, adultery by a husband or unfaithfulness by a husband was never a crime in India, but unfaithfulness or adultery by a wife was considered to be a crime. And the person the wife had an affair with could be punished. And this was challenged in Joseph Shine versus Union of India. The Supreme Court recently held that this is completely violative of women's rights to equality, and it stereotypes women, and therefore struck it down, so it no longer exists in the Indian Penal Code. The other case this year, the Indian Young Lawyers Association versus State of Kerala, which had to do with the temple entry into Sabrimala temple by women, where the court held that keeping women outside temples based on the prejudices was stereotyping them and certainly discrimination. This will have a huge impact, because when one looks at the implication of CEDAW provisions on non-stereotyping, this is an important first step to ensure that women are not stereotyped. We also see that there have been cases where the courts have stepped in, where there has been no law on the point, or there's a lacuna in the law, like in the case of Vishakha versus State of Rajasthan, where the court actually stepped in and made guidelines for sexual harassment at the workplace. Now, there have been a number of critiques of constitutional protection of women's rights. It has been pointed out that there are very few cases on areas which are very important to women, like abortion or contraception or sterilization. But very often the cases have not really brought about real or substantive equality very, very strongly. It is slow, but it is not as strong. And some provisions have sometimes been upheld which actually disadvantage women, keeping women. Now, in this chapter, we will quickly examine the public-private divide in the context of domestic violence. Now, first of all, why do we need a new law on domestic violence? There were existing laws. There was, for instance, in criminal law, your 498A, which talks about cruelty to a married woman. There are laws specifically on dowry. You have family law which allows a divorce. So if a woman faces domestic violence, either she can go to the police or she can get a divorce. But the fact is that this was really not sufficient. Why? Because there was a gap in what women really wanted. Women did not want a divorce in many cases. They also did not want to put their spouses in jail. What they wanted was for the violence to stop. What they wanted was not to be thrown out in the streets with their children, a right to stay in their matrimonial home. What they wanted was some money to tide them over while the court case was going on, or where the husband refused to maintain them, and so on and so forth. So you have a number of different provisions which the Domestic Violence Act has now, which tries to address this gap in what women want and what the law until that point of time actually gave them. We see that the Protection of Women from Domestic Violence Act provides for much more effective protection of rights of women, which has been guaranteed under our Constitution. For women who are victims of violence of any kind, which has occurred within the family, and for matters connected with such violence. So any person who has the reason to believe that an act of violence has taken place or is likely to be committed can actually go and complain. And such a person will not be subject to any procedures if the person acted in good faith. We also see that the state government has appointed a number of people called protection officers to perform a number of duties under this act. And this has been a huge support to women being able to get justice. Now, how is domestic violence defined? The definition of domestic violence, if you take a look at the slide, is very, very broad. It deals with any act, omission, commission, or conduct where it harms or injures or endangers the health, safety, life, limb, well-being, etc. of the woman, or causes physical violence, sexual, verbal, emotional, or economic abuse. It also deals with, of course, specifically dowry demand or any other property or valuable security. It also has the deals with questions where a person is being threatened and where women are being threatened in a case of a family. And this definition, if you look at it, is so broad that it covers almost every act of violence that any woman would face, be she a grandmother or a mother or a wife or a daughter or a daughter-in-law or so on. So now let's look at what a domestic relationship is, because it is in the context of a domestic relationship that domestic violence takes place. So every domestic relationship could be considered to be such, where it's a relationship between two persons who have at any point of time lived together in a shared household. They may be related by blood, it's called consanguinity, by marriage, called affinity, or through a relationship even in the nature of a marriage, like a live-in relationship, where the couple has lived for some period of time together. It also applies in the case of adoption, where people have been adopted into the family. So it is where they are family members also, where they are living together as a joint family. Now, an aggrieved person, or the person who can complain, aggrieved person is any woman who is or has been in a domestic relationship with the respondent and has allegedly suffered domestic violence at the hands of the respondent. And the respondent is any person who has been in a domestic relationship with the aggrieved person. Okay? Now, a shared household can be a household where such an aggrieved person lives or has lived in a domestic relationship with the respondent. So it can be a house that is owned by such a respondent. It can be a house jointly tenanted by them. It can be a house in which one of them has a title or some kind of an interest. It can also mean the joint family property where the respondent is a member, irrespective of whether the person has actually a right in the joint family property or not. We see that there are a number of rights, reliefs and orders which are possible under this Act. So you have a right, of course, to stay in a shared household. There are different kinds of orders you can apply for, like a protection order to prevent domestic violence, a residence order to be allowed to stay there, because otherwise a woman could just be thrown out on the street. You also have custody orders dealing with children and compensation orders. And many kinds of monetary reliefs are possible under the Domestic Violence Act. The Court of the Judicial Magistrate First Class is a person who has the jurisdiction under this Act. Now let's look at the orders. The relief sought under this Act can be sought in any proceeding in a civil court or family court or a criminal court. And you can ask for it along with other relief. And if the relief has been obtained in some proceedings, then of course it has to be informed to the court. So there is a broad procedure under the Domestic Violence Act, and this Act has played an important role in helping more women access justice. Because the first thing that most women are worried about in the case of domestic violence is, first of all, how to stop the violence, and secondly, how to have their immediate economic needs like a shelter, food and clothing met. Now, Chapter 5 deals with cultural relativism in the context of family law or personal laws. This is a slightly complicated area, and we will spend some time on this. There is always a tussle between these two concepts in human rights law called cultural relativism and universalism. Universalism holding that human rights are common for everyone, and cultural relativism holding that human rights vary based on the cultural context. To recap the model of equality we have in our Constitution, both men and women have equal protection before the law. It means also non-discrimination. Affirmative action can be taken for women, and certainly you cannot discriminate against women. Now, there is often a feeling that family law is customary law. This is not true. Family law is often a combination of statutory law or legislation, customary principles in many cases, reliance on customary text, modified to a large extent by case law by the High Court and the Supreme Court. Family law is also changed by a minor extent because of standards in international law. And this is something we will examine a bit later. In India, family law is also referred to as personal law because it's very often personal to different communities. So let's begin with some questions before we understand family law. What is law? You already know that since you're doing this course. Does law treat all persons equally? We know that law does not treat all persons equally. Children may be treated differently. Persons with disabilities may be treated differently. So does law treat similar persons similarly? Well, it might be true in some cases, but we see that similar people might be treated differently based on so many other considerations. For instance, there might be differences in tax laws in different states. You may be paying different amounts for different things. In some states, there might be penalties which are higher for the same crime compared to other states. And what is the basis for drawing these similarities? They vary. It can vary from your region, it can vary based on your age, it can vary based on so many different considerations. Now, family law or personal laws are important because the basis of discrimination, as is often called, but I would like to call it the basis of difference, is many different factors, or are many different factors. Family laws vary based on religion. So you have Hindu law, Muslim law, Christian law, Parsi law, Jewish law. It varies based on sex. So the property, for instance, of a Hindu man goes differently compared to a property of a Hindu woman. If a Hindu man and a woman are married, but they don't have children, and they die, not leaving behind their spouses, The property of a Hindu man will go to his relatives. A property of a married Hindu woman will not go to her relatives, it will go to her husband's relatives in most cases. So there are differences in the way that the law discusses both religion and sex. We also know that there are differences on religious personal laws in grounds for divorce. The grounds for divorce for a Hindu and a Christian are slightly different. Muslims, for instance, have a system of talaq which others don't have. Other than religion and sex, law also varies based on geography, based on where you're living in India. There might be customs. If you've been to a wedding, you'll see that a Hindu wedding in North India will be very different from a Hindu wedding in the South. What marriage customs are on how you get married will vary between two different communities in the same place, in the same district, in the same taluk. We also see there are differences in state laws. There might be difference in regional laws even within a particular state. There are, of course, tribal laws. In much of the Northeast, for instance, the law followed is not based on the religion, but based on tribe. In the Northeast, you will find that there are some Christian majority states, but they don't follow Christian law. They would follow their own laws. They would follow Mizo law or Naga law or Khasi law of their own tribes. Similarly, there are differences based on caste, again marriage customs and who can marry whom. Many groups in North India, for instance, you cannot marry close kin, but in the South, you can marry cross cousins, or an uncle might marry his niece. So, why does this happen? Why is the difference in the way that personal laws treat people differently? The reason is that people in different areas followed their own customs. And customary law really governed family law for a long time. But when the British came to India and they started administering justice, they set up courts. And to make things simple for them, they brought in their own personal laws based on religion. So they started applying Hindu law to Hindus, Muslim law to Muslims, their own laws to Christians, and so on. But they also continue to recognize many traditional systems. Now let's look at some of the major personal laws in India based on religions. What would they be? Major personal laws, religious personal laws include Hindu law, Muslim law, Christian law, Parsi law, and Jewish law. There are many controversies based on religion-based laws. In fact, it's not only India which is grappling with it. It's not only family law that is grappling with it. For instance, at the international level, there was a huge controversy with regard to what was called female genital mutilation or female circumcision, which was practiced in some countries, not in many, but some countries. And the whole question of whether it was violative of women's rights under the CEDAW. Well, although it became a big controversy, there were very clear standards that CEDAW had taken on this, including that you need to eliminate practices that are traditionally oppressive or harmful towards women. Now, in the context of family law, the most important article of CEDAW is Article 16. As we mentioned earlier, India has a reservation on this article, and this is an important thing because Article 16 deals with many rights dealing with family matters. For instance, the same right to enter into marriage, the right to freely decide a spouse, the same rights during the marriage and at the end of the marriage, the same rights and responsibilities as parents, irrespective of marital status with regard to the children, the same rights to decide on guardianship of children, on having children, on spacing of children, and so on. The same rights as husband and wife, including the right to have a family name. And we all take it for granted that children will have their father's names. We also see that they have the same rights with regard to ownership of property, management of property, enjoyment and disposal of property. And of course, if you look at the last sentence, there is a law relating to minimum age of marriage. Now in India, as we saw earlier, India has reservations and declarations on this. We don't completely agree with this. And because of this, we see that family law in India continues to discriminate against women on many of these aspects. We don't have same rights for women as far as property matters are concerned. We don't have the same rights for women when marriage and divorce are concerned in some communities. We don't have the same rights. Even if the law says that we are equal, women are seldom given the freedom to choose their own spouses. So family law has a long way to go until we reach really the standards that CEDAW has laid down for us. On the last point, if you turn to the end of the slide, you will look at the issue of child marriage. The betrothal and marriage of a child will have no legal effect, is what CEDAW says. But in India, the number of child marriages is quite high. Some studies have put it up to almost 40% of brides in India marry as children. So what is the status of these child marriages? The child marriages are valid unless the child wants to annul the marriage when the child becomes an adult. Because though we recognize that child marriages are bad, we need to protect the child bride and children born from such marriages. The next chapter we are discussing is what we call anti-trafficking law and the women's right to sex work. Both these sound contradictory, but they are not. The trafficking law in India is divided into different parts and found in very many different statutes, including the Indian Penal Code, which in section 370 specifically has a section on trafficking and has other sections also which can be used for anti-trafficking purposes. We also, let us quickly look at the definition of trafficking. Trafficking is defined under section 370 of the Indian Penal Code, which says whoever, for the purpose of exploitation, recruits, transports, harbors, transfers, or receives a person or person by force or threat or any other coercion, by abducting or by deceiving in some manner or abusing power or paying money or something else, would commit the offense of trafficking. Now, trafficking happens for many purposes. It can happen for commercial sexual exploitation. It can also happen for labor. A lot of trafficking actually is for labor. Bonded labor is a classic example. It may happen for marriage. It may happen for a variety of other reasons. But for the purpose of this paper, we are really going to be looking at commercial sexual exploitation. So the Immoral Traffic Prevention Act is a specific act which deals with commercial sexual exploitation of women. It covers many different sections which talk about exploiting women for this purpose, including procuring them, including detaining them in places where prostitution is carried on. And this act is very often used in cases of commercial sexual exploitation. And now let's look at some of the important sections under this act. One of them is section 4, which is punishment for living on the earnings of prostitution. So if a person exploits someone else and lives off their earnings, they would be offenders under this section. Now, in drafting this legislation, India has followed the UN tradition, but the UN has moved forward, and we have now the United Nations Convention Against Transnational Organized Crime, which has 3 protocols, out of which one of them is specifically on trafficking. It is a protocol to prevent, suppress and punish trafficking in persons, especially women and children. And it established a new universal definition, very similar to the one we just discussed for trafficking, and it legally binds states to deal with trafficking cases as per this definition. Now, in the context of sex work, there are a number of organizations which have campaigned for rights of sex workers to carry on their profession. I will deal with one or two of them. The International Union of Sex Workers campaigns for human, civil and labor rights of those who work in the sex industry. And they say that all workers, including sex workers, have the right to full protection of all existing laws, regardless of the context and without discrimination. These include laws relating to harassment, to violence, to threats, intimidation, health, safety, theft, everything. It also looks at it from a labor rights perspective, saying that sex workers work and therefore they need to have the same protections of employment, contract, property laws as anyone else would. They also talk about the right to participate in the sex industry and leave the sex industry without any stigma being attached to them. And to, of course, have access to full and voluntary and non-discriminatory health services across the board. Now, the All India Network of Sex Workers in India has also been very concerned about the plight of sex workers in India. And it submitted a report in 2016 to UN Women. It was compiled by 43 sex worker-led organizations who put together principles for the UN to draft a meaningful policy for them. Some of these included that sex workers' rights need to be recognized as human, that sex work needs to be separated from sex trade and trafficking, which have to, of course, be dealt with separately. Laws and policies which indirectly or directly criminalize consensual sex work have to be changed. And we need to create an enabling legal environment where sex workers can work unhindered. They also state that sex work is work and it needs to be recognized as a form of labor. They also say that sex workers' entitlements, social entitlements and benefits must be also protected in a similar way as other workers. Another area that has been raised and is fairly controversial is the entire area of reproductive and sexual rights, making difference costless. Very often, women bear the brunt of reproduction, and sexual rights of women are not often talked about. In societies like India, with our prejudices against talking on some areas, this becomes especially relevant. Now, the CEDAW says in its initial statement that, bearing in mind the great contribution of women to society, to the welfare of the family, and so far not fully recognized, the social significance of maternity and the role of both parents in the family and in the upbringing of children, and aware that the role of women in procreation should not be the basis of discrimination against women, and that the upbringing of children requires a shared responsibility by men and women and society as a whole. Now, this is a really important statement, but we see that this is borne out also by specific provisions in CEDAW, Article 11, for instance, which talks about the right of women to health and safety in working conditions, including the function of reproduction, and also measures to ensure that women are not dismissed because of pregnancy or maternity leave. In Article 12, we have services regarding pregnancy, confinement, and postnatal services, including adequate nutrition during pregnancy and lactation, and so on. Article 16 talks about the number and spacing of children, that women should have also the right to decide. And of course, what we've earlier seen, a specific article prohibiting child marriage. Now, as we mentioned earlier, child marriage is something that is discussed with both by criminal law and family law in India. And child marriage is considered to be voidable. That is, a marriage is valid until the child decides to have it declared void. And however, even though a child might be married, the child's reproductive and sexual rights must be seen differently from or with special provisions and special protections as compared to that of adult women. Now, this CEDAW is not the only instrument which deals with reproductive and sexual health. We have so many other instruments. The ICP, the International Conference on Population and Development, which discussed issues of access to contraception, for instance. The Convention on the Rights of the Child, specifically looking at children's rights. The Convention on Rights of Persons with Disabilities, which talks about all rights of people with disabilities, including the right to reproductive health. Now, when we talk about reproductive rights, what exactly are we talking about? There are so many ways in which we can look at this right, but in the context of this module, there are 3 ways which might be interesting for you as a student. The first is choice, the second is sexual and reproductive health, and the third is inclusion. Let's look at them in detail. What does choice mean? The element of choice is something that is so essential to reproductive rights. It includes things like whether to have children or not. We take it for granted that women have a right to do this, but not in Indian society, not in many societies. It might be decided by the in-laws or by seniors or by the husband. So women should have the choice of deciding whether to have children or not, how many children to have, what should be the spacing of the children, and so on. Another part of choice is marriage. To decide whom should I marry. Do I have the right to decide? Especially important in the context of a society like India, which insists on arranged marriages, and where most women, and for that matter, many men, don't have the choice of whom they marry. The third is the choice of sexual autonomy, and that's not just limited to marriage. It also extends to sexual intercourse and sexual freedom outside the marriage or with or without marrying. The other part of reproductive and sexual rights is sexual and reproductive health, which is much broader than simply childbearing and breastfeeding of children. It also means having access to a number of health services to facilitate sexual and reproductive health. So, of course, maternal mortality is a concern, and India has a very bad track record. However, that's not the only thing. Maternal morbidity or illnesses due to pregnancy are a very important concern, which has not been dealt with adequately. There are also health issues dealing with menstruation, or as a woman grows older, with health issues related to reproduction. Other points include access to different family planning measures or contraception measures, which includes access to contraception, which includes information on side effects, and includes men being involved in processes. Because the burden of reproduction and contraception should not be on women. Men should also have a similar burden on contraception. Now, inclusion is something which is a very, very important area, slowly being recognized. There are many cultural reasons because of which women may not be able to access reproductive rights properly. There may be controversial practices like female genital mutilation. There are other areas like marital rape. Unfortunately, it's still not a crime in India. Recognition of marital rape will go a long way in recognizing sexual autonomy and freedom of women. Similarly, there are specific groups of women like persons with disabilities whose rights are curtailed and whose agency is specifically not recognized. Finally, I would like to end on this note that both international law and our constitution have a great many standards on human rights, or rather women's rights as human rights, which we must put into practice and which need to be implemented. Women's rights are human rights. Our common fight as human beings is against patriarchy. I wish all the men and women on this course the very best of luck.